Welcome to the STARS program, seniors taking active roles in society. And now, here's your host, ANITA FINLEY.
I always love talking to professionals, and I have the big professional now. Next, Joe KARP. You know, I keep telling people Joe KARP has been with Boomer Times, and even before it was Boomer Times, it was Senior Life. And so for so long, I know him so well, and he has been such a great lawyer here for so many people. So welcome to our show this morning, Joe KARP.
Good morning. How are you?
Good morning. Great. And, you know, I didn't bring, unfortunately, our November issues coming out, but I didn't bring your November.
I have my column. I have my seminars.
Good.
You know me.
Good.
I'm a planner. I'm prepared.
I know you always are. I'm glad you did that. Okay. Well, so how is everything going on? At least we don't have the fires like we have them in California, right? It's terrible, isn't it?
Yeah, we're just going to have, if we go back to the biblical quote, the Lord said to Noah with the rainbow sign, no more fire the water next time. So we may face floods down the road.
Yeah, I know that.
Florida.
Yeah, that's true. But right now, the fire, you know, at least with floods, you can get out somehow. But
yeah,
fire's pretty hard. Yeah. Anyway, so we'll talk about
heartbreaking to see.
What?
The destruction
I know.
The destruction of animals and life.
Yes.
The good news.
I know it. I know it.
Houses, they're replaceable.
True. Well, you know, if we put this into legal terms, I was curious about, it's going to be pretty hard on insurance company. I mean, let's talk, you know, of course, the people themselves horrible, but then there's a lot of financial loss there with insurance companies and where do people go and what do they do and documents. That's why you're so good when all our documents are in your office.
We keep copies of everything. Since the advent of real good technology, we have scanned every one of our clients' documents, and so in the last 20 years we've been scanning our clients' documents, and that's a good thing. But people should take precautions. They should have, now what we tell our clients today is don't have a paper copy, because you're not going to, if you're running out of your house, you're not going to be looking around for paper. So we tell people to save things digitally. We give them, now in the last couple of years, we've given them flash drives of their documents so they can have a flash drive. They can download it into a computer. They can email it to themselves, their children, whomever they want, besides us having them. So that's an important thing, and I tell all my clients to make sure with their health care documents in particular that they email it to whoever is designated as a surrogate or a power of attorney under health care, that they have their own email to themselves so that anybody can access it. So if you're skiing and your daughter's skiing in Vail, when you're sent to the emergency room, she hears that, she can actually go to her smartphone, go to her email, and email the hospital a copy of the health surrogate. So that's pretty important stuff today.
You know, when you go to a doctor, they usually ask you now, do you have all those documents? And
sure.
You say yes, but how do they know?
Let me email it to you. I've got it right here in my smartphone.
They never ask us for it. They just ask us, do you have it? Isn't that interesting? Silly.
Well, the answer is, here's the answer. Give it to them, get it to them, because when somebody calls up and says, I want information, if they don't have access to it, then that person has to provide them proof that they're entitled to get that information.
I see. Yeah.
So it's always better that they have it in their files.
True. Well, let's cover some things now. We have a lot of your articles have been so good, because if you took every one of your articles, and I've said this to you before, you need to put it into a book somehow, Joe. You've done such a great job over the years. I'll bet. Have you saved every single article that you have ever written for Boomer Times?
I don't know, because I'm not in charge of that part of the job.
I know that. I know.
I would believe that the bulk of them have been saved.
Yeah.
I would believe that the bulk of them have been saved. And, of course, some of the articles would be out of date because the tax laws have changed and what I might have said in 1996
Good point.
is going to be different when the numbers were so different.
Right.
And also things have always changed. So, but yeah, we have a bunch of them, and my wife handles that part of the job, and she is busy enough that I don't want to throw one more thing on her back. But that is a good idea, and I will follow through with it gently, but yes.
Yeah, because you have been an expert for so long. There are a lot of people now who are experts, and other people have gotten to be board certified, and a lot of lawyers now are understanding something that you understood so many years ago. You always tell that story about the yellow pages and when you wanted to put your name, and didn't have that. But
the answer is interesting. Not a lot of other people have gotten certified. In the state of Florida, there's I was in the inaugural group of 26 that were certified in 1998. We have had certification in elder law available since 1998. Every year they allow lawyers to take the examination, go through the peer review, and go through everything and be certified. Every 5 years, lawyers have to be recertified. We got a gazillion's an exaggeration, but we have over 100,000 lawyers licensed to practice in the state of Florida. I think it's about 110 that are certified in elder law. So there's a lot of people who say we do it, but there are very few people still, if you look at the percentages, that are certified that they really have jumped through the hoops to be able to call themselves experts. And obviously, the one good thing about this is I have also, and the people in my firm who work with me, the attorneys, an understanding of where the history of the law has gone, what you can expect, what you should do, and also what occurs. There's the facts of life, because one of the things we see is with time, more and more people are getting a greater understanding. And I'm talking about the clients more than the lawyers. A greater understanding of their needs, desires, and what's going on. And
thank you, Google,
children.
They Google it, right?
Yeah, and sometimes a little bit, but they understand the concepts. How do we do it? We're spending more and more time explaining to our clients now, and our prospective clients, the people who come to our workshops. Had people in the other day. They said, would you examine our trust? And I looked at it, and I saw what it said, and it said something that they interpreted differently. They said, if our son dies, who gets his share? And I said, when? And they looked at me. I said, this trust says if your son predeceases you, his children get his share. And they said, thank goodness. We needed that to say that. I said, do you understand, though, once he gets it, he can leave it wherever he wants. He can leave it to his second wife and her kids. That's his. And I thought you said to me you wanted to, quote, make sure that this money stays in your family line. That doesn't do it. And they had that aha moment, which some of your listeners are having right now. Once it's his, it's his. And I said, but there's a way we can do it. We have a trust that we do that's a vessel as a receptacle, and it says, I leave everything in trust for my son, with my son as the trustee for him and his kids. And when he dies, that will pass to his children. I say that divorce proofs it, because it is not his alone, even though he's in charge. and it directs and requires that money that isn't spent on him go to your grandchildren. And that was an aha moment for them.
Right. I'm sure you have a lot of aha moments with a lot of people that come in for second opinions from you.
Well, with regard to stuff like that, people are starting to see the light, and they now know, divorces used to be common only with young people, but they're starting to see older people getting divorced. And they're also seeing something else that's occurred as a result of longevity, which is sometimes your son is married to the nicest lady in the world. And they're okay. She doesn't need your money. And then when he's 68 and she's 66, she dies. There is a reasonable likelihood your 68-year-old son will remarry. And he may live 15 or 20 years with his second wife. And you want to make sure that money doesn't go to her. So even if we got the greatest daughter-in-law in the world and she'd never screw her kids out of the money if my son died, there's a possibility that your son will remarry if his wife dies, or she will, if he left it to her and didn't have that special trust, he would leave it to her, the good mother, but she remarries to somebody that may not be in her same economic sphere and may, quote, need that money, even though it came from you and you wanted to pass to your line, not to your daughter-in-law's second husband, forgetting even about divorce. So we're giving people a lot of aha moments and going over it. And that's one of the reasons that we offer our clients 3-year reviews so we can go over it. Because, first of all, initially, people are not receptive to it. They're doing a trust. It's enough. They don't want to do more. And then they start to think and see. And there's so much you can give them in your initial services. You can't overload them. People sit there and they're already overwhelmed by the concept of doing a trust. And then if you say, well, we should consider doing this add-on, frequently they're just not ready for it. They're either not ready for it psychologically, informationally, or sometimes they don't want to spend the money for that additional protection. So it's something that should be done, and that's one of the reasons. And when we do our workshops, we offer clients that we believe we can help a free consultation. And when many of the people who come in already have what they perceive to be good estate plans, the question is, do they really meet your needs? And do they say what they do? People think, well, I've got my kids have power of attorney for me. So if I ever get sick, they can plan for Medicaid. And we say, well, no, because powers of attorney are limiting instruments. They can be accused of stealing your money, breach of fiduciary duty. They have to do what you authorize them, nothing more, nothing less. So it becomes an aha moment for the people when they start to see. I say, well, where can this happen? What does this do? And all of our lawyers do that, and we're trained to examine it and say, do you understand that it does this? And the other thing, I can talk about this month's column in Boomer Times.
Okay.
People think that probate avoidance is the be-all and end-all of estate planning. If I don't have probate, I don't need anything else. Well, first of all, we talked about how to make sure it goes to the right people, how it stays in the family, etc. But a lot of people do payable on death or transfer on death accounts, and they say, well, it's not a problem because all of my accounts are payable on death to my kids. I don't need anything else. That will avoid probate. And we say, well, let's talk about some of the issues, because assume for the minute they don't even own a house, because most people ain't putting their kids' names on the house.
Right.
So we say, okay, let's talk about this. And if you have a house, it really gets more serious, so we'll throw that in. You die, the money gets distributed to your 3 kids. Then they realize you have outstanding financial obligations. You have outstanding doctor bills. You have a final income tax return. You still own a house that has to continue paying the HOA fees or the condo fees. You got to pay the property tax. You got to fix the house up for selling it. If your 3 kids all get the money equally, when one of them says, hey, parent died, we need money for the house, we need money for the doctor bills, we need money for the property tax, we need money for the income tax, we need money for the funeral director, will they all kick in equally voluntarily? Or will they say, well, I needed that money and I took it already and I spent it. I paid off my own bills. Or I talked to my spouse and my spouse says, this is bull, just let's not pay it. Let's ignore it. So there are a number of things, and that can lead to familial discord. The other thing is people see, and they see it in our instruments. They see something that says, I leave it all to my children per stirpes. Sometimes they think it says stripes. Per stirpes is a Latin term that means if any of my children die, their share goes to their children, which is what most people want. Well, what most people don't realize is today, and if that's in your will or your trust, it means if your child dies, their kids prior to you. Remember, if it goes to them, it goes wherever the heck they want to put it. But if your child dies, it goes to their kids if they die before you. But many, many financial institutions today will not put that down in their beneficiary designation. So if you say, I leave my bank account to my 3 kids, the bank will not do a per stirpes designation. Ask your banks. And here's why. If somebody dies and the bank has to give money out to the beneficiaries, what do they charge as a fee for handling that?
I have no idea.
Nothing. Nothing.
That's why.
Nothing.
Yeah.
Okay? That's number 1. Number 2, if it has a per stirpes designation and one of the children has predeceased you, what do they charge to give it to that child's children? Nothing. Okay? What is their liability if they are given misinformation by 2 siblings who show up and say, well, my parent only had the 2 of us. There were only the 2 of us, no other kids. And they're lying. There's a 3rd kid. And the bank gives the money to the 2, and then the 3rd kid rears their head up later on. What's the bank's liability? Oops, we breached our duty. We didn't give this kid his share. What have they gotten for that service? 0. What is their economic exposure? 1/3 of that portion that should have been left. What's in it for them to do that? Nothing. It's liability without compensation. So many of them are now refusing to do that. So your listeners who have accounts that beneficiary designate their children, they should meet with their financial institution, banker, broker, insurance company, and say, what happens? What is the designation if my child dies? Where does it go?
Good advice, and I want to stop you because I don't want to run out of time to talk about your seminars. Can we do that? Tell me
Yes.
what they are, please, and where.
Okay. We are doing our seminars and they are the last of the year. This is it. Ain't no December seminars. We are doing 3, and one of them's in a new location. So I'll tell you each one, the date and the time.
Okay.
People can go to our website, which is KARPLAW, KARPLAW.com, to look them up and see what they are and see about our firm. On Tuesday, November 12th, in Port St. Lucie at the Holiday Inn, just north of Port St. Lucie Boulevard. We start at 1:30 and end at approximately 4. And we do our senior survival workshops. We're going to discuss estate planning, living trust, Medicaid planning, Medicaid laws, and what the laws are with regard to veterans' benefits for non-service-connected disability. Then on Wednesday, November 13 at 1:30 p.m. at the Courtyard by Marriott in Boynton Beach. Okay. Now, Thursday, November 14th.
Wait. So hold on. So Wednesday, November the 13th, 1:30 to 4, Courtyard by Marriott, Boynton Beach. Okay,
Boynton
I got
Beach
that.
On Congress Avenue.
Okay.
Now, Thursday, November 14, we are doing it at a new location for a temporary period. We have always done it at the Marriott. I have done it at the Marriott off RCA Boulevard since 1994. They are under construction and remodeling all of their conference rooms. So we cannot eat dust. So we're not going to be there. We're going to be, and this is in the on our website as well, the Velocity, VELOCITY Credit Union Community Room at 2801 PGA Boulevard. They have a large meeting room. It's in the Gardens Business Center, just north side of PGA, east of the Gardens Mall. Actually, it's about a half a block from our office. And they have a big conference room that we have used from time to time for meetings, both for staff and for some seminars. And it will be there again starting at 1:30 p.m.
Okay, wait a minute. So you said that was going to be November the 14th. Now, and that's what is that, a Thursday?
That's Thursday.
Okay, I just want writing all this down because people call me, you know. Thursday, November the 14th. Okay, and that's at the Velocity Credit Union. Okay, fine. And they can go, of course, on your website, but I need to have it for my office anyway.
Sure. And if they call our office, I'll give them the toll-free number because it's just easier than giving one, because we have offices in Palm Beach Gardens, Port St. Lucie, and Boynton Beach. So if they call our office, instead of me giving the 3 numbers, although today I don't think there's a long-distance charge for anybody anymore. It's just one number is easier. 1-800-893-9911.
Okay.
They can get information as to the location. But if they go onto the website, they can get it as well.
Okay,
and
that's good.
We'll be doing those in about 10 days, and that's going to be the last of the year.
Okay.
We'll be explaining all that stuff, and we'll be offering an opportunity for free consultations for people whom we think we can help.
And I have to tell everybody, if you haven't been to one of Joe KARP's seminars, you're really missing out. Even if you've been there, I know people go 2 and 3 and 4 times because it's always new information. They didn't hear it right, or there's always people ask questions, and then there's new information. So please be sure to go to the seminar. They are free, folks, and he's really I would call him an entertaining lawyer. He's very interesting. He's very smart, and I really hope you'll go and you'll do that. So remember, you can get online to KARP Law, KARPlaw.com, and you'll be able, if you miss this, you'll be able to get all those dates, and you don't have to make a reservation. You just show up, and nice things happen. They really do. Joe, before I let you go, I have a question for you. You see a lot of things coming on email and on the TV that talk about if you're deep in credit card, because someone asked me about this, credit card deep in debts, they can help get rid of them. How do they do that, Joe?
I'm not sure. Some of them, I believe, do the negotiation to bring them down in order to resolve them. I don't know enough about any company to say anything good or bad about them.
I see. Okay.
I would suggest that what I've done with clients where they are underwater, if you will, is I refer them to good bankruptcy lawyers that I know. And let me explain the reason. One, that doesn't mean you'll file bankruptcy. It means you will go to somebody who can give you expert advice legally and is a lawyer. And they can advise you, number one, what of your assets are safe, what you shouldn't spend to pay off these bills. Two, they have the ability to negotiate them down, and they have the knowledge that can help you. Now, I'm not suggesting any of these other companies don't, but I do know that the lawyers do. So, for example, if you were right now $100,000 in debt, not counting any mortgage, but you owed your credit cards and you owed doctor bills and you owed hospital bills for $100,000, and you have $300,000 in your IRA and your house has equity of $200,000, you have regular Social Security payments as income, and you got a modest amount in your bank account. What do you think you should do? Well, let me tell you, that may be a time you want to file bankruptcy, because guess what? Your IRA is totally creditor-proof. Your equity in your home and your homestead, unless it's related to a mortgage or a lien on the property, is creditor-proof. So maybe you got $3,000 that could be attached. Well, you might have the lawyer call up and say, go away. They might be able to get the $100,000 reduced to 10 or 15, and you'll say, I'll take that out of the IRA because I don't want a bankruptcy. Or you might say, you know what? I'm going to file bankruptcy, wipe out those debts, keep my IRA, keep my house, and I'll pay a couple of grand, whatever it is, and I don't know what the lawyers charge, to the lawyer, and I walk. I don't know when you're going to these companies, since you're not hiring a law firm, whether you're getting good legal advice.
Well, Joe, that's good advice, and I thank you. We're running out of time. I really thank you. I didn't expect you to know exactly, but I just thought you'd be able to help some people who've talked to me about it. But, Joe, I want to thank you again. You do such a great job, and we certainly appreciate that you've been here for so long in the community, working with the Alzheimer's organizations, and thank you again, and we'll talk to you another time, and we'll be reading your article in our November issue coming up.
And lastly, to all of our veterans, we thank you for our service, and may next Monday be a celebratory day in honor of you.
Thank you so much, Joe. Goodbye.
Bye-bye.